It is 8 minutes past 6 o'clock. Good evening and welcome to the show. You're listening to me, Gershwell Brooks, here on the Legal Lifeline. Wonderful to be in your company. Really excited to be with you this evening. And unlike last week, I actually have a guest sitting across from me, so I'm quite excited, as you can imagine. Anyway, guys, you know the usual story. You get a hold of us via WhatsApp. You can pop me either a text message, alternatively a voice note. And all that you have to do is you just send it to 084-221-2919. That's where you get a hold of me. And we'll try our very best to obviously answer your questions and discuss what it is that you raise here. Anyway, I'm joined in studio by a junior partner at HBG Schindler's Attorneys, and that's, of course, Mr. Matthew Ainsworth himself. Thank you so much for joining us, sir, and it's wonderful to have you with us.
Thanks, Gershwell. It's a pleasure to be here.
Brilliant, man. Thanks. So Matthew and I are going to have a very interesting conversation. So I'm going to paint the picture very quickly. So obviously, at the time, Wits, the University of the Witwatersrand, still offered the LLB in isolation. So you could do a straight LLB. So that was a 4-year degree. I'm not going to say how long that took with mine because I had a good time at university.
The scenic route, we call it.
Hey?
The scenic route, we call it.
I did take a bit of a scenic route. And anyway, so it's 4 years of study, and then obviously you graduate. And for those of you that pick up articles, it's another 2 years of articles. If you pick up pupillage, it's 6 months of pupillage unpaid. And then only once you've passed exams and goodness knows whatever else, then you can get admitted eventually. Mr. Brooks didn't take that particular route, but eventually we found ourselves here. 20 years later, admitted advocate. So that's nice. But I remember some of my classmates who were a little more studious were busy planning their futures. Now I'm going to do my articles there, I'm going to do my articles there. And obviously the ones with the big fives that got it, that got accepted at the big five, they were very happy to throw it out there. But then one person said that they were going to do conveyancing and study towards being a conveyancer and a notary. And I was like, what the heck? Another goodness knows how long in terms of study. You're going to study some more and write more exams. I mean, I'm done with exams. I'm happy to be done with exams. But Matthew, you took that path, that latter path, where you went and wrote more exams. What is the difference between an attorney, an advocate, conveyancer, and a notary? I think let's start there.
Okay, so an attorney is kind of step one in the legal path if your path is to become a conveyancer. So
sure.
All conveyancers are attorneys, but not all attorneys are conveyancers.
And thanks for making that clear, because one of the things that happened was soon after my admission as an advocate, the immediate assumption was I got a whole bunch of people asking me, hey, listen, can't you assist us with a specific thing that only a conveyancer can do? So we'll get into what conveyancing actually is, but yes. I'm just saying, so every conveyancer is an attorney, but not every attorney is a conveyancer.
Yes, so to be a conveyancer, you have to have passed an additional set of exams. Okay, so to be an attorney, you pass 4 board exams. To be a conveyancer, in addition to your 4 board exams, you have to have passed another set of exams. It's broken into 2 parts, kind of an easy, simple terms, a theory component and a drafting component. Once you've passed that, you then have to, similar to an attorney, apply to court to be admitted as a conveyancer. Once you are admitted as a conveyancer, you are one of the only professionals that are capable of transferring immovable property and registering immovable property rights in the country. When I say one of, I mean amongst other conveyancers. There's no other person that can register immovable property rights other than a conveyancer in South Africa.
Brilliant. And thanks for setting that clear. What is a notary? Because all too often they get mentioned, in a conjoined manner, if that makes.
Yes, so often conveyancers also become notaries because a lot of the tasks go hand in hand. For example, to use in property terms, if you want to transfer your exclusive use area or register, let's say, a notarial bond, that can only be done by a notary. So similar to, again, all conveyancers are attorneys, but not all attorneys are conveyancers. Not all conveyancers are notaries, but all notaries are attorneys.
Are you that rare species that's both a conveyancer and a notary?
Yeah. Attorney, notary, conveyancer. Similar to how you say you wanted to get all the studying and have it done. I decided, let me get it all done now. and just get it done.
One shot, get it done.
Like, unfortunately, not all in one shot. There are some incredibly smart people out there that get admitted as attorney, notary, conveyancer, all in one sitting.
Wow.
Mine was not in one sitting. Mine was over 3 sittings, but they got done.
Listen, brother, you got it. You got the paperwork. You got that piece of paper from the High Court saying that you can do all 3 of those things: attorney, conveyancing, as well as being a notary. So the question then becomes, look, I think let's be quite honest and quite frank about this. All too often when we do think about the law and legal professionals, for the average person on the street, so to speak, the immediate assumption is that your job is to go to court and to argue all the time. That's the first assumption. And then sort of after a while, people realize, okay, maybe they have other things that they do. So they'll help me draft a will, they'll help me draft an anti-nuptial contract, assuming that I even know that I can get married through that particular regime, etc., etc. And so it unfolds. The only time that people actually come into contact with a conveyancer is when they purchase property. And when I say property, I mean immovable property. A house, land, something to that effect, not a car. Right?
Yes, no, not a car. Immovable property, yeah.
So I'm going to ask you a very nebulous question. What does a conveyancer then do?
So a conveyancer is, to by and large, the custodian of your sale, of your transaction. Okay, you now, Joe Soap on the street, conclude a sale agreement. You're buying this apartment, this house, whatever you want to do. That then, a conveyancer then gets instructed generally by the seller to handle that transaction, to give effect and give life to the rights set out in that agreement, to take the transfer from the ownership from you to me, and to ensure all the correct payments go in the right place, to ensure all the correct compliance certificates in the right place, to ensure the contractual terminology and the contractual conditions that were set out in that agreement are given effect to. That is the purpose of the conveyancer.
So if we have to take a step back, so let's assume, I guess, a pretty big asset that people buy and sell on a regular basis is, for example, a car, right?
Sure.
So I'll take my car, I'll bring it to you, we'll agree on a price. You'll say to me, gosh, listen, your Toyota Fortuner has some mileage on it, has a couple of years behind it, your dog decided to chew on the bumper, true story. And so on and so forth. So therefore, I'm willing to pay you 100,000 rand for this thing. So I say, yeah, sure, that's fine. And then, in all likelihood, all that you'll say to me is, listen, once I've, or as a condition for payment to go through, etc., obviously we have to register the vehicle in my name. So I'll say to you, okay, we'll do that once I've received payment, and then I want you to hand me the papers.
Sure.
Right. And then maybe you'll say, listen, you can maybe fix the paint job, you can do this, you can do that, you can fix the seat that's torn or whatever. And then we agree, and that's the end of the story. I get the money, I give you the car, I give you the paperwork that comes with the car, and that's done. That's just the two of us that have the traffic department, you'll sort out, and so on and so forth. The point that I'm making is it's not quite as straightforward as with immovable property. And when we say immovable property, I'm again stressing it's either land on its own, a piece of land with some type of a building on it, a house or something, a factory or whatever. Alternatively, an apartment in a block of flats or in a complex or whatever the case is. So those are examples of how is that type of sale different. Can I come to you, Matthew, and say to you, listen, brother, I see you have a nice apartment. Here's $1 million in your bank account. It's mine now.
No, and I think a lot of people wish it was so simple. So not to get, I suppose it is a legal chat, but let's start at the beginning. So the Alienation of Land Act requires that in order for a sale of immovable property, okay, and like you said, it extends to a land and earth, which is what we call a piece of land, or a section or a unit being in a sectional title scheme, has to be reduced to writing, okay, or sold by means of a deed of alienation. So we just say reduced to writing, and signed by both parties. Okay. Now that signature can't be a digital signature. Okay. The law currently excludes immovable property sales by means of a digital signature. So say, using your car example, you guys can kind of agree. Some people even agree via email, WhatsApp. Hi, I'm going to swap cars with you. Here's the money. You guys have got a deal. Here's the POP. Happy, fetch your car tomorrow. You're done. Okay. Whereas with immovable property, it's not so simple. If you've done an electronically signed agreement, that agreement is not actually a valid sale agreement, and it can't be given effect to on that base point. Okay?
Wow.
So that's step one. So now let's say you've got a completely valid sale agreement. Okay. Whether you've concluded it privately through an estate agent or property practitioner, or either of those things, you've now it has to go to a conveyancer to give effect to. Why that has to happen? The conveyancers then attend to the drafting of all the legal documents. So as the seller, you'll deal with certain things like your power of attorney to pass transfer. You'll deal with the draft title deeds. You'll deal with all the various FICA affidavit requirements. SARS is a big one, that kind of thing. You'll deal with we'll facilitate all the role players in the process. Because when you lodge, so now we say to minimize the process, say we've gone through all that, everyone signed everything, you've paid the various things you're supposed to pay. In the deeds office cover that we lodge for your transaction, has to be a draft title deed, has to be the original title deed for the new property if it isn't for the existing property.
Sure.
Unless it's bonded, in which case it's linked with another piece of paper. We can get to that later, but irrelevant to the point, I suppose. Inside there is your transfer duty receipt. Inside there is your rates clearance certificate. So those are other role players that we as conveyancers facilitate. So like having to get SARS paid, having to get your rates clearance certificates facilitated. We then, when we prep and we lodge the documents, we sign what's called the prep clause. Okay? And this is where the fact that we've taken oaths and gotten admitted and all those kinds of things come into play, because there's a duty of care and responsibility on us.
That you have,
and trust that society places in us. So when we sign what's called the prep clause, so let's just say when we sign the deed, okay, to put it in simpler terms, we are taking responsibility for the legal accuracy of that agreement. We are confirming that the right people are selling. We are ensuring that the right status of those people exists. We are confirming that the correct conditions that are supposed to be in that title deed are in play. We are ensuring that the correct bond is actually a part of the agreement. We are ensuring that the bank's interests are involved. We are ensuring that you as the seller's interests are ceded and passed along, that the purchaser's interests have taken control thereafter. We then also handle, as part of the attorney component and part of the conveyancing component, the trust management of money. So we then, similar to you now, you're handing over what for most people is the biggest asset they have in their lives.
Exactly.
Okay. This is, as much as a car is a big asset, we're talking often for people upwards of $1 million, okay, for the asset they have. Now, when do you hand over those keys? As an example, I'm saying in your car example, it becomes a bit more easier. I've got the POP, cool, here's the house. Okay. Whereas in a property example, we ensure that money is protected until both rights have been maintained. So it's actually registered. Your ownership has been released. Your ownership has been registered and protected in the Public Deeds Registry's office.
I find that absolutely stunning and fascinating, considering that I think all too often, you know, and it's a realization that I just had, because Matthew, you will excuse my ignorance, even though I'm a legal practitioner. I didn't know, as we would say colloquially, it was that involved. Because all too often what ends up happening is my interaction, in fact, I can't think that I've ever met a conveyancer in person per se, unless I was sitting there and just signing a couple of documents, and was I even sure that that is the specific person, or, you know, or it could have been their secretary or their assistant or whatever, you know, or article clerk. But the point that I'm making is that it's usually through an estate agent. The estate agent says, listen, these are the attorneys that we normally work with. You're free to bring your own attorneys on board, but we work with them because we have an arrangement, discounted rates, blah, blah, blah. And so they'll do all the paperwork. And you assume that, look, ultimately it's just a formality, you know, because we have this archaic law that somehow buying and selling land has to be reduced to writing, and some lawyer has to be involved, and they have to take that cut. But I mean, you made it absolutely clear that it's a very involved process. So that electrical clearance certificate that you need, the plumbing service, plumbing compliance certificate that you need, your rates and taxes being up to date, and all of those things. So your job is to make sure that all of those things are in place, and that nothing is missing, I take it.
Absolutely, because beyond, once that's done, and the last stage in the process is kind of the lodgement process.
Yeah.
That's when the deeds office takes control and audits the documents, for lack of a better description. They examine them. They go through them and they make sure that this makes sense, that the right people are involved, all the legal componentry from what's the word I'm looking for? I've gone blank now, like a compliance perspective
Yeah.
with the Deeds Registries Act is in play, that everything is in line from that position.
Sure.
And then it gets examined by more than one examiner. It's an incredibly safe process. You mentioned archaic just now as well. Yes, I suppose in a lot of parts of the world, a lot of these things have become more digital, have become more faster moving, less paperwork. But
AI driven.
Yeah, we have one of the most secure property registry systems in the world.
Yeah.
Because, and yes, a lot of it is because of perhaps the archaic nature of it. There are steps to each process. First, you've got the agent, then you've got the conveyancer, then you've got the first examiner, second examiner, sometimes third, sometimes even the registrar. And then you get some matters that get kicked out of the deeds office at the point of execution.
Seriously?
Because the registrar or the final examiner has picked up something at the last moment. Well, we have a question. Or this is missing, or whatever needs to take place. So that when someone tells you your property has registered, you are secure in that moment.
I get you.
It's passed through so many steps that at that point in time, you can say, cool, that no one can turn to you afterwards and say, oh, you didn't actually register my property. Not to say there aren't a few crooks out there that
or
try
things
and prey on
go
that,
wrong at some point, yeah.
Exactly. But once it's reached that point, you're good. It's one of our favorite calls to make. Hi, listen, open the champagne. It's the house is yours today, kind of thing.
And it is, I mean, if memory serves me correct, I mean, it's not, no, believe me, I'm not that guy, and I'm in no position where you're purchasing a property every 2-3 years, right? But
Sure.
It's been a while. How long does the process take again? It takes a couple of weeks, isn't it? A few weeks.
It can. I mean, obviously, we can talk about what each office aims for, but
Sure.
I mean, a nice, good, quick transfer is 6 weeks.
Yeah.
Long transfer is probably 12 weeks. Obviously, these things vary based on what the agreement says. Sometimes sellers and purchasers agree we'll only register in September, and then that's obviously a 4-month transaction. Sometimes it's how fast can you get it through. Some of our team get transfers through in 4.5 weeks, record breaking. We're very proud of them. Those are the exception, not the rule, but they can take place. If everyone plays their bit and the seller comes to the party with all the stuff they're supposed to supply and the purchaser does the same and everyone signs and everyone gets their bond and everyone's part of it, these things can move.
Yeah.
But sometimes they don't.
But I mean, it's still an indication. I mean, it's, taking, where your record breaking period is, say, 4.5 weeks, standard is 6 weeks, long period is 12 weeks. That still gives an indication that it is an involved process. It's not something there's no short course for this. That's the point that I'm trying to make. There's no quick, I'm straight out of matric and I want to become a conveyancer. You need to understand there's a legal obligation on you. I liked what you said, that obviously the cover page, that ultimately it holds you to account as the conveyancer. So all too often when we talk about the legal profession, it's one of the most, it's a heavy profession. I'm going blank now. The point that I'm trying to make is there's a lot of liability. That's the word that I was looking for. If you're an attorney and you're practicing and the client gives you money, there's a trust account for that. And you're supposed to hold that money in trust.
Yes.
You're supposed to obviously use it ethically.
Yeah.
And the same applies in this particular instance. And that people get disbarred and all kinds of things happen because they haven't done the right thing.
Absolutely.
And
we
I take
are
it that
creatures of instruction.
Yeah.
That's if you wanted to sum it up, we are creatures of instruction, and it depends on where the instruction comes from and who we are obliged to take instruction from. But like you say, with trust money, if it's not your money. I had a principal once who used to call it monopoly money. It's not real. It's there. It's only real for the person whose money you are the custodian of it for.
I wish that your principal gave that lecture to a couple more of our colleagues, unfortunately.
No, absolutely.
But I mean, that's a separate conversation altogether. No, thanks for that. I think up next, what I want to discuss with you, Matthew, is I want to dig in a little deeper, because I think all too often, in as much as we have a very formalized system when it comes to immovable property within South Africa, a lot of things happen in a very informal way. You gave me a couple of examples in our conversation prior to starting the show, and I really want to dive into that because, and for the listeners out there, because you weren't privy to the conversation, obviously, what typically happens is I have a property in my name, and then, I'm 80, I'm 90, I'm not here anymore, and then Michael comes along and he says, I'm the eldest and I was supposed to get the house, right? But now this house is registered in Joshua's name, my second son. Or it's registered in Joanna's name, my daughter, my third child.
Yes.
And now there's a dispute, and people aren't happy with what happened and how the thing got transferred, and so-and-so crooked and stole and took it out underneath me and so on. We will get into those details after this. Welcome back, folks. And sitting across from me is an awesome guest. It's, of course, Mr. Matthew Ainsworth, who is that very, very rare endangered species attorney, conveyancer, and notary. And we're talking about property law. Shane coming through via the WhatsApp line saying, good evening. I'm very happy to hear your guest turned up. Thanks to both of you for your time. Have a great evening. Cheers, Shane. Shane, thank you so much. I think you deserve another shout out in terms of whatever song it is that you want us to end the show off with. Please do give us a shout. And for the rest of you that do want to get a hold of us, you know how to get a hold of us via WhatsApp. Of course, you can send me a text message. Alternatively, you can send me a voice note, and it's very simple. You know the number by now. It is, let me just make sure, 084-221-2919. That's where you guys get a hold of me. Drop me a voice note, alternatively a text message. That would be greatly appreciated. Anyway, moving back to the conversation that we were going to have there, Matthew. The one thing that stands out for me is I think you and I have established that we have a very formalistic system when it comes to the transfer of property. So going back to my very bad example earlier, I can't come to you and say to you, listen, I got $1 million here. I'm buying your flat or your house or whatever, and it's done. Here's the keys. There's proof of payment, and we're happy. That doesn't happen that way. But unfortunately, in as much as it's very formalistic and formal, what tends to happen is that there are disputes that come up. I gave the example earlier on that, for example, I'm 80, I'm 90 eventually, and then I'm not here. Michael comes along, my eldest, says that the house was supposed to be registered in my name. But now instead it's registered in Joshua's name, my second son. And then let's throw another spanner in the work. And my daughter comes along and says, well, my name was on the will for the house, but now it's in Joshua's name. How do those types of disputes occur when we have such a formalistic system with all these checks and balances in place? I mean, is there a straightforward, clear-cut answer to how does that end up happening? Or
generally, it's like most lawyers are going to say, it comes down to the paperwork. Okay, so in that instance, you mentioned your daughter saying, no, she's the one and the beneficiary in terms of the will for the house. So then if that is the correct will, it is the right document, because there's layers to this. So it ended up in the quote-unquote, say, wrong person's name somehow, which means that either there was those rare occurrences of some sort of degree of a fraudulent transaction, which they happen, even in all things, well, they do happen, but there has to be layers to that kind of fraudulency that takes place. And it would have to have been to a degree based on something, and that transaction would generally have to have involved a conveyancer. That's it. Not generally, it has to involve a conveyancer.
Sure.
Which means at the very least, the starting point in that transaction is you get a copy of the title deed or the existing ownership. You see who's on it. You then start the question backtracking. Who signed the prep clause? Who's the conveyancer? The circle of conveyancers, yes, there are quite a few of us, but it's not as big as you think. And I'm sure you can attest to it. The legal fraternity is not as big as you think. It's one of those where reputation is terrifyingly important because you get known. You interact with people, people find out about you, etc. So then you start backtracking from there. You go back, Mrs. Joe Soap was the conveyancer, you try and find them, they're registered on the LPC website, whatever it is. How did this take place? What was it? How did it go down? She has an answer. She doesn't have an answer. You work it back from there. If it turns out that that will, for example, is the correct will, it was the correct will, and there might have been an error that took place or a fraud that took place at the time of the reporting of the estate, which I think that ventures into a different field of law that I'm going to stay away from for now. And so there's not always a straightforward answer.
Sure.
Where it becomes much more problematic is in the absence of documentation.
Ah.
So where all you have that exact same dispute, but you take out the fact that your daughter has a copy of the will.
Yeah.
Okay, you take it out, and we replace, say, your son inheriting with the neighbor has the house. Okay? And now the children are saying, no, it's actually supposed to go to us. We were your surviving kids. It should be our house. Why has it gone to the neighbor? But now all there is in this circle of problems is the final document, is a title deed that says it's in the neighbor's name. And now this dispute's arisen. The children have come to me and said, Matt, help us. It's supposed to be our house, but they can't give me anything. They can't. It's supposed to be my house. And that's it.
And that's the tough one.
And that's, again, then we start having to fight about things like intestate succession. Is there not? Neighbor might produce a sale agreement that got signed 40 years ago or whatever down the line, and that's suddenly what was utilized to get registered. It is a complex thing. None of these matters are considered in isolation. Each of them is new. Each of them is different. And we always, and again, I mentioned to you before we started, the three things you don't tell people you are at the BRI is a doctor, a lawyer, or a commissioner of oaths. Okay, because they always come to you and say, I've got a quick question, I've got a quick thing. And our response, and a hard thing in all professions like that, is to step back and say, let's chat. Send me the stuff you've got. Let's talk about it, and not give advice off the cuff, because that's how disputes like it should be my house comes up.
That's how I know you're a nice guy, because you take it to the extent where you say, listen, send me the stuff and then we'll discuss it later. Brother man, I'm at that stage of my life where I'm like, listen, unless you're able to pay.
Sure.
But no, you know what? But and this is a brilliant cop out for me as an advocate. I can't take instruction directly from the public. I have to take it. I have to be briefed by an attorney.
That was calculated. I can bet you. I bet you. You thought about the conveyancing exam, and you were like, no. I want the barrier.
I want that barrier. I need that barrier, because all too often people come to me, hey guys, this. It's a simple, straightforward thing. It's simple and straightforward, but I can't say anything to you, brother. You have to call. You have to call. I, in fact, have an attorney for you. Speak to him. And then obviously the attorney says, fees. This is how much I charge.
Sure.
Deposit, and that's usually, look, that's how you separate the wheat from the chaff, unfortunately.
No, absolutely.
That's, again, another conversation altogether. But coming back to what it is that you are highlighting now, and you know, it's a thought that I had, is that, so say, for example, Gershwell in his young days as a bachelor.
Sure.
I'm a bachelor, and I think, hey, listen, I need to put my money into something useful. I've been drinking and jollying a bit too much, and my money needs to go into something useful, and a property would be a great thing. So I buy a little flat.
Sure.
So I live in this flat, and then I meet someone, and things work out beautifully with me and this person. Boom. We married in community of property. Not out of community of property, in community of property. We didn't bother going back to Matt's firm and sitting down
all the notary
with
stuff to do an anti-nuptial contract.
None of that stuff. And here we are, boom, we are married in community of property. Now remember, I bought this thing before I got married. The title deed, I've paid it off. Title deed has my name on it.
Sure.
I kick off this mortal shell that they call life. What happens next?
So let's
the missus is surviving.
Missus is surviving. Let's go into the version where let's take a will completely out of the equation in this conversation. So your spouse, by virtue of your marriage, regardless of her name being on the title deed or not, is automatically an owner of an undivided half share in that property. Okay, so say your estate decides to sell it out. So she doesn't take ownership. She decides, you know what, I will take the bucks. She's the sole heir. She's going to inherit everything. Whatever. The transfer takes place. She then inherits. She has taken ownership of half of that property simply by virtue of the nature of your marriage. Same thing happens if you die. If you get divorced. My apologies. Yeah.
And can I just? I'm sorry to add in another slight complication.
Sure.
So for whatever reason, I decided to leave it to my neighbor in the will. Right? So bought this thing before we got married, registered it, and now it's in my name because I've paid it off.
Yeah.
I kick off this mortal shell, but I drafted a will, and for some whatever weird reason, I've left it to the neighbor. Does she still have an entitlement? Because remember, her name is not on the title deed.
Sure.
The will says it goes to the neighbor. Does she have a right to go to the neighbor and say, not so quick?
Yeah, she's still entitled to an undivided half share.
Brilliant.
Half of that is hers.
So, in other words, the source of
All he could sell is essentially his half share.
Yeah,
So that neighbor gets half a house.
half a house.
And if everyone played ball and agreed to it. But yeah.
Well, clearly they weren't playing ball. Why on earth did you leave the house to the neighbor? Something is amiss. Anyway, I guess the ultimate point behind it is that so inasmuch as that deeds registry is confirmation and final confirmation of who the owner of the lawful and rightful owner of a particular piece of immovable property is, I guess there are other factors that also have a role to play. So, for example, was there a marriage contract? What are some of the other things that we need to take into account?
I mean, that's a very key component. Was there a marriage contract? Another one is, and this is one that comes up quite often, is not only is there a marriage contract, but how were you married according, what country's laws govern your marriage?
Oh, okay.
So we get a lot of it in South Africa,
Yes.
where people who were married according to the laws of another country or whatever, wherever they were living, whatever the story was, they've come to South Africa now and they're like, listen, we're going to buy a house. Okay? Our law dictates that if you are, because we can't be expected to know all the laws of all the countries in all the world. Okay? As a safety mechanism, the spouse, so say my wife and I are going to go buy a house and we're married according to the laws of England. Okay?
Yeah.
The safety mechanism, if I'm going to go buy a house cash, okay, I can sign by myself. The documents will say Matthew Ainsworth married according to the laws of the United Kingdom, whatever. Not a problem. If I buy and I have a bond, I'm now binding what was considered the joint estate. Again, we don't know the laws of England or the marital regimes, so the safety net is on the side of caution. My spouse will need to sign the bond documentation. The banks generally all require it. There's never an exception, by and large. Okay, that would mean that now the spouse has to sign the bond documents and the actual bond that gets registered at the deeds office. Because not just title deeds, original bonds get registered at the deeds office and at the nuptial contracts, all that kind of stuff. So now they have to have signed as duly assisting their spouse. Okay. Then what that also means now is that the transfer document, the title deed and the bond have to match. So now suddenly the wife has to also sign as a duly assisting party when they're purchasing the property. Because they have to match. Both names need to be on it. Okay, not necessarily as a duly assisting, but both names need to be on the documentation. When I sell, same story, married according to the laws of another country. Okay, I got married, I owned a property here, I was living here, I was South African citizen, still a South African. I moved overseas for 10 years, I resided there for 10 years, I got married, met the love of my life, came back, still owned the house. I'm now selling. Okay, we're now classified as married according to the laws of another country. My wife then, and the alienation of that, the sale of that property is considered an event that affects the joint estate. She has to sign as duly assisting in the sale.
That is actually fascinating, and it's great that you're mentioning that, because recently I had to do a divorce between two Zimbabwean nationals. They got married in Zimbabwe.
Sure.
And what I wasn't aware of up until that particular point is that marriages in Zimbabwe, unlike in South Africa, where if you do not go to a notary,
the default position is
community of property. Whereas there, it is automatically out of community of property. So obviously, it was in front of a magistrate in the regional court, and she wasn't going to have it. She wanted proof that they made out of community of property, even though Zimbabwean law says that automatically you're married out of community of property unless you do the opposite and you go to a notary to say that we want to be in community of property. So that's very fascinating. So even in that example, two Zimbabwean people that are married out of community of property back in Zimbabwe, when they're buying and purchasing property and selling property in South Africa, both partners need to be involved.
Yeah.
Hubby
The
can't
rare
say,
exception is where it's a cash purchase price.
yeah,
Where
sure.
it's purely cash, there's no binding of the joint estate or the quote-unquote joint estate. Then you can, by and large, your marital status is noted, but you don't necessarily have to act with your spouse. Okay?
Sure.
Because it's almost classified as something good for the estate. You're adding an asset to the
Yeah,
estate.
yeah.
Whereas when you are binding the estate or selling us an asset in South Africa, which would have a negative impact, quote-unquote, on the estate possibly, your spouse, because, like I said, because we don't know, like exactly like the magistrate in that instance had to request a declaration as to how it functions, how the world works, because we don't know the laws of every part of the world. And it does become quite frustrating to a lot of our clients who are married according to different regimes around the world, where suddenly we say, Mr. Man, we completely, or Mrs. Man, we completely understand that you want to buy this house, but you're taking out a bond, or you're selling the house, and now your spouse has to duly assist and sign with you.
That's absolutely fascinating. So, as you said, when it comes to property and the law of property, there is no, my father told me that the house will be mine. There is no other document. I can't go and write, unless it's an actual will, because I guess you take the will after the passing of a person and you go to yourself, and I'll sit across from you, Matthew, and I'll say, you have a will. And according to this will, I'm supposed to inherit the house. I'm the sole beneficiary when it comes to this particular house, and then we'll go through the process from there.
Yeah,
right?
That's where the law of estate law and administration of estates and conveyancing mix.
Sure.
So then it becomes, do you have executorship letters? Has it been reported to the master? We can't just on the face of a will start transferring a property. It has to go through another regimented process of the reporting of the estate and attending to that kind of thing.
But legally, we can go in that particular direction.
The eventual result,
Sure,
should all T's and I's be crossed and dotted, is that the property gets transferred in effect of the will's contents.
I'm sure my kids' ears are itching. Michael comes to you and he says to you, no, because I always use them as examples, especially when I'm talking about...
It's a safe bet.
So Michael comes to you and he says to you, Matthew, there was no will. But Daddy told me, because I'm his favorite son, I behaved myself all along. I was not a hooligan, that house is mine. The other two can get everything else. They can get the business, the car, the whatever, the shares, the what. None of those things, by the way, I own. One can only dream. But the house is mine. What then? What do you tell Michael?
So again, this is where it becomes a mix of conveyancing and intestate succession.
Sure.
Okay, so that's not my specific area of expertise, but the laws of intestate succession would have to have been followed. So it would how it would devolve from your surviving spouse to your children, and each one kind of gets a share in breaking a child share, or the greater or the lesser thereof, as the assets are divided. If the beneficiaries, all in terms of intestate succession, all kind of reach agreement and say, you know what, Dad was right, Michael has to get the house, we'll take the shares, then redistribution agreements and so on get signed, and we act in accordance with those. And again, it follows the estate process. There's no just, here's the will or here's the redistribution agreement, just do it, please transfer me the house. You still have to follow, and again, an unfortunately regimented process.
And we also live in a country where obviously we have there's a lot of contestation around history and so on and so forth. But the point that I'm really making is I can't just wake up tomorrow morning and say that a piece of felt used to be mine or my family's. I take it that that very secure system of deeds registry can go all the way back to... I don't know if I can say it on air, but 19... how far back does it go?
I mean, I haven't been into since the deeds office in Johannesburg, for example, has moved. But when I was practicing in Cape Town, you go into the archives, there are some deeds that are handwritten on blue paper that were carted back and forth by horseback. They're old.
1800s.
Yeah, there are some. They basically live there for the purposes of archives, so that sometimes there's title deed conditions and stuff that have been diluted or devolved to the point where you have to kind of go back and find out what the original intention or the original contents or the original design was supposed to be. And so they exist for that reason.
Because I guess I could say, I don't know, Yanni has a farm, and Fani comes along, the younger brother, and says, you know what, Yanni's actually using the farm for sheep farming, but as a precondition of this particular will, our great-grandfather said it needs to be wine farming. And if it's not wine farming, then we must sell the thing.
Yeah.
And then you go back and you have to go dig
You go
that
and you
up.
hunt it down, because those conditions of a will, for example, so then again, this is where the interplay between estates and conveyancing comes into effect, is if your will says, like almost every will, or any well-drafted will should say, that any inheritance here is excluded from any matrimonial property regime or in community, etc. That condition gets put into that will.
Okay.
Into that title deed. And only for so long as obviously that person is a owner. And if they say I inherited the property from my parents, and it's in that will to say that it's excluded from the matrimonial property regime, and then I sell it on, it comes out. Because now, what's the point in having a condition to say that it's excluded from my matrimonial property regime if I've now sold it to you? So it then just it comes out of the title deed.
Sure, because I can't come and buy your property and then you preventing me from my wife benefiting from it in some shape or form. Final question that I have for you is, I mean, for anyone listening to the show, I mean, I guess the vast majority of people listening to the show would have gone through the usual mechanism of registering a property through a bond, etc., etc. After 20 years or 30 years of paying your bond, then, yay, deeds office says now it's yours, Mr. Brooks, on your own. You don't have to worry about this bank, or whatever else. It's yours, and it's perhaps the missus's, right? So, sharp. But we have, a contested history. People were living in townships for a very long time, but they couldn't own land. They couldn't buy immovable property. And at some point, government went ahead and said, listen, we're going to give you title deeds for this. But all too often, those people didn't get physical documents. They were told that you have a title deed. And it's registered in Mummy and Papi's name. The question is, if anyone wants to find out, where do I find out about this thing? Where do they go? How do they go about it?
So the deeds office is technically a public institution. So those records are publicly accessible. It is like anything, like going to Home Affairs, like going to anywhere.
A challenge.
A process.
Let's call it a challenge.
Yeah, there's no queues or anything of the like, and and this is not blowing smoke. It's one of the most efficient governmental departments in the country, as far as I'm concerned. And yes, I may be biased because it's the field I work in, but they are incredibly efficient. And so there is a public, you can go there, you can pay it's like a nominal fee for a copy of a title deed, or if you've got a name you can do a search. The easiest thing normally is to kind of just approach a conveyancer that you can find or know, even through pro bono or something like that, where they can do a search. You search via ID number, you tell me roughly where the property is, we can try and find it. And often there'll be, and we discover some weird and wonderful things where some of these old title deeds or old deeds of ownership or cession or whatever they've become have got strange names and things, and we end up searching and finding them. And often it becomes a document we don't see very often because, like you said, it goes back quite some time to fix a problem that had taken place, and now this document kicked in, and we can obtain copies of them.
Brilliant.
That copy doesn't necessarily, you can't transfer a property with a copy. There's a whole other process we could talk about for another 3 hours about how you obtain another registrable
So you're
copy.
definitely coming back.
There we go. You could take another registrable kind of copy. We always talk about it as a Reg 68 in the office, which is basically a new registration copy.
Brotherman, let's do this. We'll have to end it here now because of time. But please come back. And I just realized that we didn't discuss part 2 or part 3 of your very illustrious career, and that is the notary side of things. Right? We didn't really go into that. What is a notary? What does a notary do? I'm definitely having you back. I hope you don't say no.
We're happy to.
Folks, I know you enjoyed that one. Thank you so much. That's cheers from myself, Mr. Matthew Ainsworth. Thank you for coming through.
Absolute pleasure.
Awesomeness. And up next, I keep on saying this, man. I'm sorry to say it. The coolest lawyer I know is going to start the show up next. It's the Rock Road House with Michael Timvius. I'm looking forward to listening to it as I drive home. Cheers, folks. Up until next week.